Right. Okay, hi everyone. I see we have around 40 people so far in the session. We're gonna actually wait another minute or two until we start, just to give people a little bit more time to join. But thank you everybody who is joining today's session. We really hope to make it as informative and helpful as possible. One of the features everyone should be aware of on today's session is there is a Q&A box on the bottom where you should be able to type in a question. We want this to be as interactive as possible. If you have any questions, please feel free to drop them in that Q&A box. We also have a couple of prepared questions that are, should be pretty universal, should be, addressing a lot of the questions that we all have about this new law. And so if we don't get to your question, or if, we cover it with one of our earlier questions, please just be aware, keep that in mind. And it looks like we're at around 126 so far. Let's give it one more minute. And okay, just to give a brief intro, our goal with today's presentation about good cause eviction is to discuss the new law, which has really mystified a lot of people in our industry. We're going to cover the main framework of, what is good cause, give a general background, what are the knock-on effects and practical takeaways for everybody who's in today's session. One quick disclaimer I want to put out there is this session is not intended as legal advice, as each situation is unique. This session is intended for informational purposes only. And I think, it's 4:02. I think we're going to go ahead and just get started. So thank you, everybody, for joining us today. I'm really honored to have two amazing guests who are going to help us. First of all, it's my honor to introduce Sherwin Belkin. Sherwin is a founding partner of the Belkin Burden Goldman LLP group and has represented owners in numerous proceedings and hearings before a vast range of bureaus, departments, and courts. Mr. Belkin has lectured at seminars and is frequently called upon for interviews by the New York Times, the Wall Street Journal, The Real Deal, and beyond. I'm also honored to introduce our guest, Jeff Goldman. Jeff Goldman is also a founding partner of Belkin Burden Goldman. Starting in 1989, he is a co-managing partner and co-head of the litigation department for over 29 litigation attorneys, representing small and large owners and condo and cooperative boards related to landlord-tenant issues, general commercial litigation, foreclosure, and all real estate related disputes in civil, state, and federal court. And then I'm also joined by my colleague, Adam. Adam Hirsch is one of my favorite people at AKAM. Adam is also the vice president of AKAM's Multifamily, Commercial, and New Development Department. Adam's been with AKAM for over 3.5 years and responsible for the department's overall operations and growth. And just given his background, given his knowledge, I thought it was very, very important to include my colleague Adam in today's discussion, as he's the one who, from our end, deals with a lot of these topics and a lot of these issues. So Sherwin, I'm going to turn it over to you and Jeff to just give us a general summary, a general background of, why we're all here, good cause eviction.
Okay, thank you. Thanks to Gil and Adam and the whole AKAM team for putting this webinar together, excuse me, and inviting my partner Jeff Goldman and I to participate. Good cause eviction has been in effect for a bit over 2 months, and I'd like to briefly touch upon what good cause eviction, GCE, is and what GC is and what GC is not, because there are many misconceptions about this law. Preliminarily, now that the law is in effect for 2 months, I'm often asked, when will DHCR promulgate some guidance clarifying the many issues that GCE is created? The answer is never. DHCR has jurisdiction over rent-controlled and rent-stabilized apartments. GCE units are neither. They are free market units with some new limitations. So DHCR has a very limited role when it comes to GCE, which was promulgating the CPI number, promulgating the HUD number, promulgating a notice that'll issue in August. Beyond that, DHCR has no role. A second preliminary, GCE raises a host of issues without clear statutory answers. And as a result, much of the discussion you're going to hear today will involve Jeff and I looking at aggressive interpretations of the law, conservative interpretations, and interpretations everywhere in between. In fact, Jeff and I may not agree on some of the interpretations because the law is unclear and it depends how aggressive you want to be. Ultimately, absent some clarity from the courts, the legislature, or the Attorney General's office, owners will need to make their best business judgments based on a risk-benefit analysis as each situation arises. So what is good cause eviction? At its core, it's an eviction limitation law. Those tenants subject to GCE can only be evicted for the good causes that the law sets forth. For those units, owners have lost the ability to simply say to a tenant at the end of the lease, I'm not renewing your lease, you need to vacate without any cause. That's gone for GCE tenants. What GCE is not, it is not a rent overcharge statute. It doesn't calculate legal rents. It does set presumptions about reasonable rent increases, which in turn can limit an owner's options on renewal. So now I'd like to briefly turn to what is this reasonable renewal increase under GCE as one topic. Second, what housing is exempt from GCE? Because if you recall, good cause eviction was first floated in 2019 by State Senator Salazar. That law went through an awful lot of changes to get to 2024. And though I'm not a big fan of GCE, one of the positive changes are the number of units that were excluded from coverage. Once I've touched upon that, I'm then going to turn it over to Jeff, who's going to talk about the requisite notice that needs to be attached to all renewal leases and vacancy leases, and the good causes of eviction that the statute still allows. So looking at the reasonable rent, what the statute essentially says is that on renewal, an owner can raise the rent by a reasonable amount. What is a reasonable amount? It's the lesser of 10% or the CPI plus 5%. DHCR is designated to determine the CPI. It determined CPI was 3.82. Add 5%, that's 8.82. So an 8.82 increase on renewal is a reasonable rent increase. An increase beyond that amount raises a rebuttable presumption that it is unreasonable. Now, the statute does create grounds under which one can increase rent beyond the 8.82, and we can talk about that as we go on. But I think one of the big issues is what is exempt from GCE. So rent stabilized and rent controlled units are not covered by GCE. Affordable and income restricted units, not covered. Co-op and condo units, completely exempt from GCE. Construction where a TCO or C of O is issued on or after January 1, 2009 is exempt from GCE for 30 years. It's an two things about that. It's very unclear. Is that the first TCO? Is that the first C of O? Or at any point along the way, if you get a new TCO or C of O, does that create the exemption? The other thing that's interesting is GCE has a 10-year sunset provision, yet this creates a 30-year exemption. So the statute only exists for 10 years, but you could potentially get a 30-year exemption. Further exemptions: units in buildings of 10 units or less, if owner occupied, are exempt from GCE. Small portfolios, meaning 10 units or less within New York State, are exempt. And lastly, luxury rents. This is again a figure determined by DHCR. The HUD fair market rent unit increased by 245%. As of today, exempts the following categories of units from GCE. For a studio, if the rent is $5,846, a one-bedroom at $6,005, a two-bedroom at $6,742, a three-bedroom at $8,413, or a four-bedroom at $9,065. So that's the basics, and I'll turn it over to Jeff.
Oh, thanks, Sherwin, and thank everybody at AKAM. I just want to touch on the notices briefly and how that interplays with certain statutes that are already in effect. As Sherwin said, the notice has to be attached to every vacancy lease, every renewal lease, every notice that might be served, whether it's a rent demand, notice to cure, notice of termination, and a petition to recover possession. And it has to be attached regardless of whether or not it had been attached in the initial lease, and now you're giving them a renewal or a vacancy lease. The notice has to be given to what the statute says is any lawful occupant or tenant. What that practically means is even if you are commencing a licensee proceeding, you still have to attach that notice to a notice to quit. Now, the notice has to be given and it has to advise the tenant or lawful occupant whether or not the GCE applies. And if it doesn't, the reasons why it does not. Now, if it does apply, as Sherwin noted, you do have or may have a good cause to terminate or not renew. And one of the reasons that I just want to focus on very quickly is the definition of small landlord in the statute. As Sherwin noted, a small landlord is somebody who has 10 units or less. But what does that mean? If it's an individual, it's fairly easy to make that determination, except the way the statute is written, you have to explore whether or not you have a direct or indirect ownership interest, and even a beneficial ownership interest. So you may individually own 10 units, but you also have a 1% interest in a trust or a 3% interest in a limited partnership that owns property. And the same goes for an LLC. The GCE notice requires you to identify the members of the LLC and what their interests are. And if one member out of 3, 4, or 5 hold more than 10 units, direct or indirect beneficial ownership, then you are not a small landlord and therefore apply, the GCE applies. In the notice, if you are saying that you are exempt as a small landlord, you have to identify the individual or individuals and the properties that are within that 10 or less threshold. Now, that is also going to result in discovery issues in housing court. And even if you do identify it and say you're a small landlord, tenants who want to delay can use the discovery process through that. Another issue for everyone to consider, there are 2 statutes. The HSTPA created a statute that requires an owner to notify a tenant more effectively for a 2 years tenancy, more than 90 days, whether or not you're not renewing or if you're increasing the rent more than 5%. GCE says that that kind of notice cannot be sent more than 90 days. So you have an HSTPA notice that has to be served more than 90 days. And you have the GCE notice that has to be served 30 to 90 days before the lease is over. What does that practically mean? You're practically going to have to serve two notices, the HSTPA notice and then a GCE notice. If you are renewing the lease, the tenant has to either accept or decide not to renew. The notice does not provide, nor does the HSTPA notice, when that tenant has to tell you that they are renewing. GCE is silent about that. We recommend that you put a date by which they must accept the renewal lease, the failure of which they will have to get out by the end of the lease term. Leaving it vague and open-ended will only invite a lot of delay and problems as to whether or not the lease was properly renewed. Now, there are grounds for removal in the statute, and they are the typical grounds that are found in the rent regulatory field: nuisance, breach of substantial obligation, failure to pay rent, all the typical failure to provide access. It is not clear whether or not those are simply grounds to terminate, which you always had that right, or they are grounds to renew. By that I mean, if you've served an illegal sublet notice or a nuisance notice in year one, and now the case is being prosecuted, can you serve a GCE notice that says, due to the pendency of the nuisance proceeding or your failure to pay rent, we are not renewing your lease? I do not believe the courts will ultimately find those are grounds to not renew. I think they would be considered grounds to terminate. But again, that is an issue that's going to have to be decided in the courts. In various seminars, and to just wrap it up, in various seminars that judges have held in the various counties, the judges right now have no clue what they want to do. They are going to take it one case at a time, and which only means there'll be disparate treatment across counties and across judges. The notices, let me just roll back for a second. The notices need not be attached to any leases or notices, the GCE notice, to any leases or notices until August 18 of this year. However, the courts are going to be interpreting the law to any proceeding that was commenced as of April 20 of this year. So you may have made an offer pre-April 20 and it was accepted, but the lease didn't commence until after April 20. And the question will be, what law will the judge follow? You may have made an offer before April 20 and the tenant never signed it. And now the tenant's saying, I don't want to sign it. These kinds of decisions, as Sherwin kind of noted in the beginning, are going to be business-related decisions to whether or not it's worthy of fighting a 15% versus an 8.82% increase. But I will close with this. It is critically important, since you can get more than the 8.82% based upon documenting real estate tax increases, maintenance, insurance, fuel, utilities, significant repairs to the apartment or the building, to begin to document that now. Have a folder somewhere where you're accumulating that data so that if you choose to increase it beyond the 8.82, you have that ready for your attorney in court to demonstrate the support why you're entitled to a 15, 12, or 20% increase. So I think there's probably a question or two out of the over 150 or so people out there. So go ahead.
Yes, excellent. Thank you so much, Jeff, and thank you, Sherwin. I'm just going to run through some of the questions that Adam and I had put together before. There was a quick question from two different guests asking if today's webinar, if the slides are going to be available. Certainly, we could definitely share those. That's definitely not a problem. So just some of the questions I'm gonna sort of ask to summarize some of the things that you brought up earlier, but who without question is definitely exempt from GCE?
Sherwin, you want to take that?
Who without question, rent controlled, rent stabilized, income restricted, co-ops, condos. The issue about the C of O or TCO after 1/1/2009 is more of a gray area as to what that means, but the absolutes are the rent regulated co-ops and condos, the small portfolio that Jeff mentioned, and the high rents that I mentioned. Those are absolutes.
And let me just add, if I can, Gil, for co-op boards now who on sales and transactions are issuing new proprietary leases. That is a lease. So it would be prudent to use a form notifying the new shareholder that they are exempt.
Okay, excellent.
I just want to let everybody know that the Q&A is open. So if you have your hand up, feel free to put your question in the Q&A box. And if it hasn't been answered, we will get to it. Sherwin, you had referenced luxury rent, which is also known as 245% of the market rent. You had rifled off a couple of numbers just for everybody listening. Where can we find that list, and how often does that change?
My understanding is that both, although it is not crystal clear in the statute, but what I've been led to understand is that both the CPI number, which leads to the 8.82, and these luxury rental numbers will be promulgated annually by DHCR. If you go to DHCR's website, look under good cause eviction, you can find these numbers.
And one of the questions in the chat is relevant to the exempt units, tenants that receive a subsidy. So maybe they're in a fair market apartment, however, they're receiving some sort of voucher. Would they be exempt? Would that unit be exempt?
I believe they are exempt.
Adam, do you want to ask that question about the age of property, if that has any?
I think we've answered that one. It's anything newer than 2009.
Well, let me just address that. So, good cause eviction, the statutory idea is not new. It exists in many jurisdictions around the country. New Jersey's had it for decades. In California, they passed good cause eviction, and they had a similar provision which related to new construction. I don't know if when the legislature promulgated the provision for New York State, if it intended new construction. That is a building that got its first TCO or C of O after 1/1/2009. What if you had a building built in 1985 and you recently split units, added a unit, did some work to get a new C of O? Is that building now exempt? There is nothing in the statute that says it's not exempt. It just says the issuance of a new TCO or C of O. I don't know if that's what the legislature intended, but it's an unclear issue. There will certainly be owners that are going to push the envelope on this one.
Another question that we had are related to lease terms or the term of a lease. Some people have asked, what if a lease term is less than 12 months? Which, we'll pose that as one question, but what about a multi-year lease? If if a landlord wants to enter into a 2-year lease that has an increase for year 2, how would that second year increase be calculated? Is it a variable? Is it fixed to this current year? Does it change when the new statute comes out? How should that be addressed?
You want me to take that, Sherwin?
Go ahead.
Okay. So let's assume you do a 2-year lease now, it's 8.82%, and we don't know what year 2 will look like, but we do know that you can only get 8.82% a year. The clause as to what the rent would be the lower of, and then you would have to put in the lower of 10% or the CPI as promulgated, plus 5%.
You know, in talking to clients, I have suggested that while we are all kind of feeling our way through this, they may want to do 1-year leases only until we have some sense how this applies to 2-year leases. There's nothing in the statute that talks about lease term. There is one sentence that talks about being limited to one reasonable increase per calendar year. If you think of that, that could indicate that you only get an increase in a 12-month period. So doing leases of less than 12 months may mean that you don't get a second increase within the second calendar year.
And the other thing that's missing from the statute is whether or not you can get a larger than 8.82% increase on a vacancy lease. So you have a lease for 8.82%, tenant decides to leave. Are you limited to another 8.82%, or can you increase it 20%? My reading of it is, since the intent is not to increase rents to compel a tenant to leave, and therefore we want to minimize a tenant being forced out by large increases, from a legislative policy purpose, there should be no prohibition from increasing the rent to whatever one would want. Now, that makes logical sense. It doesn't mean the legislature would necessarily see it that way, but I don't know if you agree or disagree, Sherwin, on that.
No, I agree with you, and that's why when I said at the beginning, what is good cause eviction? At its core, it's an eviction restriction statute. So that's referring to tenants in occupancy not being forced out by high rent increases. That would not seem to apply to tenants first coming into occupancy.
Excellent. One of the topics that's come up a lot in our discussions with with owners is regarding fractional ownership. And so I'm going to ask the question we had pre-prepared, but I'm also going to take a question from the floor here. So generally, if you're an LP or you're a GP with fractional ownership, you own a piece in a building. How will they treat that? One of the parameters for good cause eviction, size of a landlord's portfolio that they own. Another version of this question someone actually put in the Q&A box is, if an LLC has an 18-unit building and there are 2 owners, 50% each, does that fall under GCE? How do the HUD FMR rates apply to the neighborhoods? Okay, that's the second question. But yeah, fractional ownership, how is that going to be treated?
I think, given the definition of if you own or are a beneficial owner directly or indirectly, in whole or in part. So if you are a fractional owner and you have 18 units and you're in an LP where there are 2 people, each person has and it only takes one person. Each person has an interest in 18 units, and they're not small.
I agree. Gil, I also want to mention our discussion today is really New York City centric. Outside of New York City, jurisdictions can opt into GCE. but the 10-unit portfolio is 10 units in the state of New York also. It's not just the city. And I agree with Jeff.
Meaning that's all included. The courts are going to look at all of that, even if it's a separate jurisdiction.
Yes.
Correct.
Wow. Okay. And so they will look at each of those partners as, hey, you own 18 units, even though they have fractional ownership.
Yes.
Okay. That's interesting. The other question that I wanted to make sure I got to was regarding condos and co-ops. I know Sherwin, or I know Jeff, I know you talked about this briefly, but regarding condos and co-ops, I know you said that they're exempt, but I just wanted to hammer the point home, if somebody owns, I don't know, say you bought a unsold shares in a building, or say you own 10 condo units, that I just wanted to hammer this home that you're exempt, or are you exempt?
I believe you are, regardless of count. It's an independent
I agree.
exclusion.
It's a class of apartments that's exempt.
Got it. Okay, excellent. Thank you for that. Adam, you wanted to cover some of these also, right?
Yeah, so while Sherwin, you had mentioned that, the 100% fair market and 245% luxury rate, as well as the CPI, comes out annually. Specifically to the CPI, if your notices go out prior to the new change and the lease will take effect after that change, does the renewal notice need to be adjusted? Let's say if the CPI goes up or down.
We just got the first CPI notice, assuming it's going to be promulgated annually. We have 10 months to figure that out. My hope is that DHCR will promulgate the next CPI notice in advance, so that by the time the renewal offer must go out, which is 90 days before the lease expires, we know what the new CPI number is.
So what I read was it was on or before August 1st, which is really in the heart of renewal season. We're hoping we get it, in May, like we did this year.
I hope.
One of the questions someone asked here, which I thought was a great question, is there a boilerplate GCE notice that we landlords should be using?
The entire notice is in the statute.
Okay.
The DHCR's entire role is taking what is in the statute, putting it on a piece of paper, and at the top of the piece of paper, printing New York State Division of Housing and Community Renewal. The entire notice is in the statute. I'd also mention that although Jeff is correct that technically DHCR doesn't need to promulgate the notice until August 1st, and technically the notice doesn't need to be attached until sometime thereafter, the Real Estate Board of New York did promulgate a notice, a facsimile notice early on, that many owners are attaching to leases under the theory that good cause eviction is already in effect. The statute says it applies to pending proceedings, and just so that owners are not having any of their proceedings potentially tainted or subject to attack, there are owners who are presently attaching the facsimile notice to their leases.
And pleading it in the petition.
Right.
So a lot of the questions that we've had are surrounding the topic of vacancy leases. For a vacancy lease, can you just increase the rent to any number, or is it subject to the prior rent, similar to a stabilized, rent stabilized apartment? A lot of the questions that we've been getting are around that. Another one someone asked in the chat is, if a unit is vacated, can the rent be increased with or without significant investment in the unit? So yeah, if either one of you could just give take on that.
Sure, I think I indicated early, we believe you can, given the policy behind GCE. And there is currently no registry of rents, so owners who fall within GCE don't have to register with DHCR or anybody as to what the prior rent was. So a rent can go up to whatever one would want. Now, it doesn't mean that in the next legislative session, this is not a slippery slope to there's going to be some sort of registration system so that you can't take, a too big of an increase. I know some of our clients have asked questions such as, if I'm going to get a vacancy increase, and I'm at $2,000, can I take it to $3,000? Obviously, we think you can, but then give 1 or 2 months off, so the net effective rent is lower. You can. Net effective rent has a whole different set of legal issues. Right now there is no reason to do that unless you want to preserve a higher rent, thinking something's going to happen in the future.
But I just want to mention, I agree with Jeff. It would have been so easy for the legislature to have a sentence in the statute. The reasonable rent limitations are wholly inapplicable to vacancy leases. They could have said something if they wished to. Instead, it is one of the innumerable gaps, lack of clarity.
They're silent.
I don't know if it's intentional, if it's being cute, if it's oversight. So Jeff and I are giving our interpretation. Could a judge make a different interpretation? It's certainly possible. I will tell you, I have clients who have said, I see no limitation on vacancy leases. Whatever I think the market will bear, that's what I'm going to charge. Conversely, I've had some clients who say, you know what, I don't want to be the guinea pig. This is all going to be thrashed out in the next year or two. 8.82 is not such a bad increase. I'll even take that on a vacancy increase. I'll live with that. So, and everywhere in between. These are business judgments people are going to have to make.
And let me just also add, even with the 8.82% increase, and we talked about if you want to get it above 8.82, you can look at repairs, building costs and expenses, how a court is going to interpret a 10-unit building versus a 200-unit building, what the expense increases are versus their rental income portfolio. A lot of owners have had leases where the rents are low because of COVID and other reasons. It's the list of factors to be used by a court to determine reasonableness is not an exhaustive list. So if you have apartments in your building where similarly sized situated apartments are renting from much higher, and now you have a lease coming due of a similar apartment who has had the benefit of low rents, one of the factors could be, I'm renting this identical apartment across the board at $3,500, this $2,000, it's not an unreasonable increase given the market. How judge will interpret that? I'm being a little more aggressive than probably Sherwin would be on that argument, but it is a factor that the courts could, if they want, consider to determine whether it's reasonable.
Yeah, Jeff's correct. My guess is that things like what the rental market is, courts may be less convinced by that. If you look at the list of factors, they generally relate to out-of-pocket expenses for things like insurance, taxes, etc. So I don't know how many housing court or other judges are going to say, oh yes, I really see a reason for this owner to get full market rent. It may be less persuasive.
Jeff, you had alluded to earlier that there is no really central reporting system similar to how rent stabilized units are recorded. So it really seems like a self-regulated and a self-administered situation in terms of increasing rents. So in the event that you had increased the rent above the threshold, tenant signs a lease, tenant continues to pay, maybe they're unaware of the GCE guidelines, and then they start to fall behind into arrears. And obviously you're over the threshold, and you can't evict that person for not paying the delta above the threshold. Would the landlord be subject to any damages?
Well, two things that are kind of melded together. So part of the question may be if today, a tenant 3 years from now says, I understand that when the prior tenant left in 2025, you didn't take 8.82%, you took 15%, you should have taken 8.82%. One, therefore, I have been overcharged. And two, whether or not you have decided to take 10% instead of 8.82%, and now looks back years later and says, I have been paying too much. There is no overcharge interpretation mechanism that's laid out in the GCE. It doesn't mean the Attorney General couldn't investigate an owner to see if that's a widespread problem or not. And it would appear that the damages would be limited to the amount that was overpaid, likely legal interest, presumably attorney's fees.
Would that be in the, and again, I know this is hypothetical, but do you think that would be in the current term, or would you be able to go back, let's say, like you said, 3 years from now, they've signed 1-year renewals? Would it only be in the current term that they identified the overcharge, or would they go back to the original tenancy?
They would have the right to go back to their original tenancy. There's no waiver by once you sign the second lease that you've given up your rights in the first lease.
But the question is, what rights did you have? You had the right to say, I'm not signing that renewal lease at a 10% increase. You had an absolute right to say, I'm not signing it. You need to give me a renewal lease at the inflation rate of 8.82. Instead, you signed it. You went on about your business. You then signed a new renewal, and now you're raising a complaint. I think there are real questions in this statute about what actually are the tenant remedies. I understand it seems intuitive that the tenant seems like they should be entitled to some monetary refund. But the statute doesn't use the word refund, doesn't use the word overcharge, and it does say damages by a tenant are applicable in 2 situations only, where an owner has committed fraud by saying, I'm not renewing your lease because I'm removing the apartment from the rental market or I'm demolishing the building. The statute says that's when the tenant could get damages. So I understand it absolutely seems that to create rights with no remedy makes no sense, but this statute just has glaring gaps. And I think this is all going to have to really be thrashed out and potentially remedied by the legislature in a subsequent bill, because this one is just, we're all just like playing in the dark and clutching for straws.
The only thing I would just say to that, though, is the argument that a tenant could
I love when Jeff and I have a fight before several hundred people.
It's the collaborative effort. The argument that tenant didn't have to, could have. The practical reality in housing court and Supreme Court will be no different than in the rent regulatory challenges. Nobody challenged it for years. They could have gone to DHCR. I just think the practical reality is,
Right.
as
You
long
know,
as, as long as
from
the
a,
notice is attached and
from
you,
a, from a practical perspective, I 1,000% agree with you.
okay,
But from a statutory legislator's perspective, rent stabilization has an entire overcharge, rent calculation, refund mechanism
I
in the
agree.
statute. There's not a word in this statute about that. So you have a judge creating an entire statute, an entire overcharge, rent calculation, and refund procedure without a specific statutory basis. It's going to be an interesting set of months in front of us.
Do you think that the legislator is going to solve this, or do you think that this plays out by setting a precedent in court?
I think in the short term, you're going to have cases that are in court, principally based on timing. Absent some emergency session, the legislature typically does not come back into session until January of 2025. And then it tends to deal with the budget until April and only deals with housing and other issues between April and June. So I'd anticipate between now and then, you're going to have different judges making different decisions with different findings.
And just to add to that, whenever the legislature does ultimately, if they do address this, it's not going to be pro-owner. It
ain't getting better.
It ain't getting better, number one. And number two, if, again, if you are creating a challenge that one anticipates is going to go higher than housing court to the appellate term, it is really, really important to have your attorneys create a strong record, both with documents and facts, as well as legal arguments, because the appellate courts will only make decisions based upon the record below. And if the record below is not strong, meaning you didn't make every legal argument, you can't make a new legal argument at the appellate level, and you didn't put in facts that should have been put in, you may lose a winnable case. So it's really important to have a good record and good counsel preparing that record.
I'm going to ask another one of our pre-prepared questions, but I'm seeing so many in the Q&A box that I want to get to. There's a lot of really good ones. But one quick practical question. How do you anticipate this law affecting housing courts, which are already backlogged? Do you think it'll make it better or worse?
Just when you well, certainly won't make it better. And just when you thought it couldn't get worse with delays in housing court as they are, it will create more litigation than there used to be. And now, given the issues that good cause eviction raises, they would be more likely to have discovery, which is more motion practice, which are more court appearances, more expenditures for owners, which again should all be in the calculus of whether or not it's worth fighting over 3 or 4%, from an 8.82 versus 13 or 14%.
One really good question I saw, again, this really practical, someone asked, is what sources do courts use to verify ownership portfolio size when verifying small landlords? There's no database currently that exists that has this information. And so, yeah, that's just a practical question of how are they going to go about that? Jeff, you mentioned discovery and.
Well, first, it's the owner's obligation to identify the names of the individuals and the properties in the good cause eviction notice. So when you attach that notice and you say you are not subject to GCE because I'm a small landlord, if that gets challenged and you've identified the names and the addresses, a decent attorney, doesn't even have to be a good one, will say, Judge, I think they have more than 10 properties. And I want to explore that. It's too easy to lie and omit properties. And that's going to be the first battleground. And most owners don't want to open their books as to what they own, what are the properties in the city or outside the city, who are their partners. Most people don't want that.
Yeah, my guess is this small portfolio, when owners realize how invasive it is about the information that you have to provide, my guess is that from a practical perspective, unless you're a single owner of
Right.
a small number,
Right.
I think it's going to be not particularly used, because you just don't want to be opening yourself up to these sorts of inquiries.
Understood. So, okay, this is another really, really practical question. I love this one. If we have a lease, which is a free market unit with 1 month of free rent, where they pay the net amount, when the renewal comes, do we increase based on the gross rent or the net?
You go
Okay,
first,
so-
Sherwin.
Mhm.
You go first.
Okay, so rent concessions has been an issue that's been a hot topic in rent stabilization for the past couple of years. So let's look at a practical example. Assume you have a 1-year lease, $1,000 a month, and you gave 2 free months. Over a 1-year term, the rent that you collect is $1,000 for 10 months for a total of $10,000. Net effective, it's $833 per month. So what amount do you use? The statute says exclude from the definition of rent any additional charges like health club, parking, ancillary charges. It does not say exclude from rent concessions, reductions. It also says rent is the amount charged and paid. In the example I gave, the only amount ever charged is $1,000 a month. The only amount ever paid is $1,000. If you had to bring a non-payment proceeding, it would be $4,000. So you come to, this is one of those, are you aggressive or you are conservative? I'm normally conservative on these sorts of things, but on this one, I tend to be aggressive. I would probably use the gross rent and not exclude the concession. The reason being, I see nothing in the statute that tells me to exclude it. There are certainly some that will say, I don't want any issues, I'm going to use net effective, but on this one, I'd probably take a more aggressive stance.
Right. And just, I agree, but it's important that the tenant or tenants not pay rent, not that the net effective is 800 and they
Right.
pay 800 for 12 months, that they actually pay 1,000 for the 10 months. And given the exclusion, as Sherwin indicated, for amenities and other services, there are reasons that an owner may want to increase the cost of amenities, which are not considered rent, if one wanted to increase their rental income without triggering the 8.82%.
So I just want to make sure that a point that Jeff made, which is very important. If in the example I gave, where the tenant is getting 2 free months, if the 2 free months were input by the tenant paying $833 a month for 12 months, then I think the rent charged and paid is $833. And I think that's the amount you have to use. I think the aggressive posture really only works on the rent concession notion.
But I think Sherwin and I would both agree, we are litigating and there are a lot of cases in the rent regulatory field regarding why is it that you gave a 2-month concession, you really did it for purposes of getting a higher rent, ultimately getting the 8.8 on the 1,000 rather than on the 800, and what was the reason for it? And that is active pending litigation in the rent regulation field. I don't think there's a lot of money to be made by tenant lawyers in challenging this net effective concept, but it's something to consider.
One thing I would do based on what Jeff is saying, which has worked well in the rent regulatory rent concession cases, if you're giving a concession for a specific reason, this is a new building, you're moving in under a TCO, half of the building amenities are not ready yet, and the lobby is going to be under construction. I would create a rider that specifically details why the concession was granted, so that it isn't just you plucked it out of thin air so that you could create a higher base rent, but
Right.
that it was for a real legitimate business purpose.
Or your apartment is along a sidewalk bridge and the views aren't great, or there's going to be local law 11 work
Right.
being done, and those are legitimate reasons why you would do a net effective.
Excellent. Okay. This is another really practical question someone asked. Is a renter who is subletting entitled to GCE protection? And is the law silent on that?
No, the law says that a tenant who is subletting can claim an GCE, assuming the unit is covered by GCE. It provides that the tenant has the right to say, I'm not renewing under GCE if the tenant intends to move back into the apartment as the tenant's residence. What's really interesting is generally tenants need the landlord's consent to sublet. Let's say the tenant has no interest in moving back into the apartment, but the landlord has said to the tenant, no, you've sublet for 2 out of 4 years, which is the maximum. I'm not allowing you to sublet again. Is the tenant then able to say to its subtenant, I'm not renewing? There's really a conflict of statutes there.
But why would a free market tenant, assuming a free market tenant wants to sublet, why would a landlord ever agree to have a tenant who's on a 1-year lease or has 15 months left to sublet beyond the 15 months, knowing that? But circumstances arise.
Right.
All right, we're coming up on 1 hour. Before we wrap up, before we cover any closing questions, Jeff or Sherwin, did you have any practical takeaways you want us to walk away with? You want our listeners to walk away with any closing remarks?
Sherwin, you can go first. It's like the debate tonight. You go first, I'll finish.
Okay, shut off Jeff's mic.
Oh, baby. Yeah.
I really think we've covered the topics. I wish we had more absolute answers. That's my big takeaway, that owners, managers, brokers, you're really going to have to pay attention to the legal news going forward to see what are the decisions that come out. Does the Attorney General weigh in at all? Because, as I said, we're all kind of feeling our way in the dark, looking for specific answers on a statute where a lot of specific answers don't exist. So, I wish we could have been not more helpful, but more specific in answers.
Absolutely.
I agree.
This is why it's called a law practice.
Yeah, we're practicing. When we get it right, we'll let you know.
Yeah.
The only thing I would add to that is whether it's GCE or non-GCE, every owner or management company should document. It will reap rewards down the road. So just keep a paper trail.
I think that's the best takeaway. Start now, waiting until the issues arise and scurrying around looking for documents at that point, it's most likely too late.
Absolutely. All right, amazing. Thank you, gentlemen, so much. I really appreciate both of your time. Really, just this is a topic that I know is going to keep coming up in the next couple of years, and it's only going to continue. You know, being a you know, an area of confusion for a lot of landlords, and so I think today's discussion really clarified a lot. We're sharing a screen now with everyone's contact info. If you have any questions for any of our speakers today, or you'd like some help with commercial management, residential management, any of the above, please contact myself and my colleague Adam Hirsch. And that's it. Thank you so much. And for all the people who have been asking in the Q&A box about receiving a recording or receiving any materials, we are going to be sending out a link to the recording in full. We're also going to be sending out, I believe, a bullet point summary of some of the key takeaways from today's discussion. And we're also going to be releasing some bite-sized clips on LinkedIn. Stay tuned of today's questions so you don't have to rewatch the entire webinar if you have any, you know, if you have a specific area you wanted to touch on. So that's it. Without further ado, I really appreciate everyone's time, everyone who joined, everyone, you know, who all of our panelists who spoke today. And that's it. Thank you, everyone.
Thank you, everybody.
Thank you.
Thank
Bye-bye.
you.
Have a great night.